Welcome to literary and jury charge practice. Let's get started with this jury charge. Ready? Members of the jury, any action of this kind is based upon a claim that the defendant had been negligent because the law would not permit you to find a verdict for the plaintiff or to award any damages unless you should conclude, first, that the accident resulted because of negligence on the part of the defendant, secondly, that there was no negligence by the minor plaintiff which contributed in any way to the accident, and thirdly, that the injuries and the death resulted from the accident itself. Negligence is a failure to use the care and caution which a reasonably prudent person would exercise under these same circumstances. The reason that the plaintiff cannot recover without proving negligence on the part of the defendant is that the law does not raise any presumption just because an accident has occurred that the defendant has been negligent. That is a matter which you would have to find from the testimony. On the other hand, the law holds that if a claim is presented on behalf of anybody, there can be no recovery if that particular person was himself in any degree responsible for the accident. That is what is called contributory negligence. If any negligence on the part of the minor plaintiff contributed to the happening of the accident, there could be no recovery. In this case, inasmuch as the minor plaintiff died as a result of the injuries, the law raises the presumption that he was careful and that he was not contributorily negligent. It would be essential, therefore, for the defendant to prove contributory negligence on the part of the boy. That will be one of the questions you will have to take into consideration. It is your duty to determine the facts. It is your duty to reconcile the testimony as far as you can, bearing in mind the fact that no two persons recount a thing exactly the same. Bear in mind the further fact that there is apt to be a little confusion on the part of witnesses inexperienced in court when they get on the witness stand, and consequently minor discrepancies may appear. You take all those factors into consideration and you bring to bear in passing upon the facts your judgment as to who has been telling you the truth. In other words, you pass upon the credibility of the witnesses. When you do that, you may take into consideration their interest in the outcome of the case, if any. I do not mean that just because a person may be interested in the outcome of a case that he or she is not telling the truth, because obviously in many instances they do tell the truth. That is merely a factor for you to consider. You bring to bear all those qualities that you have acquired as adult human beings, which enable you to determine whether a person is being truthful or untruthful. All right, let's now practice some literary material. And this is an article called The Judge. Ready? He asked me not to move my extension cord or to put my hair behind my ear. He constantly snapped photos for reference of anything that may be moved between takes that might later be sought out by People's Gaff Squad. After much tweaking of camera angles, running dolly tracks, fiddling with light towers, and yards of gaffer's tape, Robert Downey Jr. appeared on the set. He looked fit in a supple blue pinstripe suit, as energetic and sleek as a panther. He got his lines with David, the other actor in the scene, down perfectly, and strutted out of the courtroom quite happy with himself. There was no need to do another take, but they did one more anyway, just in case. When the day was done, it was close to 7 p.m., and for my work on the set at Plymouth Courthouse, I was paid $101.53 after taxes. You can see me in the first courthouse scene in the background, pretending that I'm taking down what they're saying. Would I recommend that you try your hand at acting the part of the court reporter if the opportunity arose? Absolutely. Back to our jury charge. Ready? Although I shall refer to the facts, you take your recollection at all times in preference to anything I may say. It may be that I will make some error inadvertently in discussing the facts, or I may overlook something that you think is important. So you trust your own recollection. It is also your duty to determine what inferences flow from the facts that you think are established by the weight of credible evidence. Your verdict must be unanimous. You take your instructions as to the law from me, but you are the proper persons to determine just what happened in this particular case. You must arrive at your verdict without either prejudice or sympathy. You have absolutely no right to find a verdict against any defendant because you sympathize with the plaintiff. You would have no right to find any verdict because of prejudice or any feeling of that kind. You are, as briefly as I may put it, an impartial, fact-finding body, and you approach your duties in an entirely dispassionate frame of mind. The first question for you to determine is how this accident happened and where the responsibility lies. I may say to you that the duty upon the part of automobile drivers is to handle their vehicles at all times with proper care under the circumstances. For example, when a motorist comes to a street crossing, he is not free to drive quite as rapidly or quite as freely as he might drive in between streets. He must take into consideration the fact that he is coming up to a crossing. Also, if a motorist is going to make a left turn on a street where there is two-way traffic, it is obvious that before making the left turn, he must exercise special care to see that there is no traffic coming in the opposite direction before he is at liberty to pull across the other traffic lane. Now for some more literary practice. Ready? Ask any court reporter or captioner about the various assignments they've worked, and the answers can range anywhere from a small-town court case to a papal visit to a major sporting event. In the case of NCRA member Megan McKenzie, RPR-CRR, Arlington, Virginia, an official reporter for the U.S. House of Representatives, reporting the 2016 State of the Union address delivered by President Barack Obama, was just one more high-profile job well done. A court reporter for 15 years, McKenzie said she began her career with the U.S. House of Representatives in May 2006 after a fellow court reporter suggested she apply for an opening that was posted. She began by reporting committee hearings, investigations, and press conferences before moving to the House floor in May 2008 to make the congressional record. During her time working on Capitol Hill, McKenzie said she has also had the opportunity to take testimony from actors Richard Gere and Ben Affleck, as well as musician Ricky Martin, former New York Mayor Michael Bloomberg, former Federal Reserve Chair Ben Bernanke, and human rights activist Martin Luther King. She's also taken testimony from members of the U.S. Supreme Court, the President's Cabinet, military officers, refugees from war-torn nations, and the CEOs of several major banking institutions. In my opinion, reporting for the U.S. House of Representatives is the most interesting court reporting job because of the wide variety of content we are exposed to, the caliber of witnesses who come to testify before Congress, the excitement of being on the House floor when there is an important vote pending, and the ever-changing political environment, McKenzie said. She noted that in comparison to the diversity in the technical content she is regularly exposed to when covering the armed services, financial services, and foreign affairs committees, among others, a presidential speech is much easier and requires very little preparation time. Covering President Obama's last State of the Union speech to the nation wasn't the first time McKenzie has reported or captioned an event with a president in attendance. To jury charge practice. Excuse me. The subject of this jury charge is non-communist affidavits. Ready? Section 9 of the National Labor Relations Act, as amended, provides that the board shall make no investigation nor issue any complaint on behalf of a union unless there is on file with the board a non-communist oath of each officer of the Union and of each officer of any national or international labor organization of which it is an affiliate or constituent unit. Section 9 further provides that the provisions of Section 35A of the Criminal Code shall be applicable in respect to such affidavits. Section 35A of the Criminal Code applies the criminal sanction of perjury to false affidavits filed under Section 9H. The question in this case is whether criminal prosecution under that provision is the exclusive method of enforcing the mandate of Section 9H, or whether the board may take administrative action and, on a finding that a false affidavit has been filed, enter an order of decompliance, withholding from the union in question the benefits of the act until it is satisfied that the union has complied. The court below held that the criminal sanction was the exclusive remedy for filing the false affidavit. That decision is in conflict with a ruling of the Court of Appeals for the Sixth Circuit. We granted the petitions for certiorari in each case in order to resolve the conflict. The union filed a complaint with the board charging that the International Scientific Company refused to bargain with it in violation of the act. During the course of the hearing before the board, the company challenged the veracity of affidavits filed by one Turner, an officer of the union. The board, in accord with its practice, refused to allow that issue to be litigated in the unfair labor practice proceeding. But later on, it issued an order directing an administrative investigation and hearing. A hearing was held before an examiner who found, among other things, that the affidavit filed by Turner in August 1954 was false, that the union membership knew it was false, and yet continued to re-elect him as an officer. The board agreed with the trial examiner. It held that the union was not and had not been in compliance with Section 9H of the Act, and ordered that the union be accorded no further benefits under the Act until it had complied. The board thereafter dismissed the union's complaint against International Scientific Company, an action later vacated pursuant to a stay issued by the court below. Now come to some literary material. Ready? Other noteworthy assignments have also included captioning President George H.W. Bush's speech on the anniversary of the Americans with Disabilities Act in 2005, Vice President Joe Biden's Family and Friends Party prior to his inauguration, where country singer Faith Hill performed and President Bill Clinton spoke, and the Let Freedom Ring concert held in celebration of Martin Luther King Jr. Day, where President and Mrs. Obama were present. In 2014, McKinsey also reported an address by Ukrainian President Petro Poroshenko to a joint session of the U.S. Congress. McKinsey attributes her ability to play the piano as part of her success as a court reporter and credits her parents for suggesting the career path. When I was in high school, my parents suggested court reporting as a career for me because they knew a court reporter and thought it would be a good fit. I had played the piano growing up, so I already had experience with that type of manual dexterity. I definitely think playing the piano helped me progress through school, and have heard from other reporters that playing the piano was helpful for them as well. And that will conclude our literary and jury charge practice.